for that within 5 days, and we'll see you in a couple weeks. Good
Okay,
luck.
thank you.
Deerfield versus Emilio Castillo. This is file number 2505285. Mr. Castillo, your name?
My name is Emilio Castillo.
Counsel, good morning. Your appearance?
John Capitan, I want to appear on behalf of Deerfield Estates.
So I went out and saw the property this morning, and
Yeah, sure.
at least the exterior of the property. All right. What do you want to say?
Well, you did have the opportunity to go out there. You took photographs. Yeah, I hope you saw the dog excrement that was just riddled on his front lawn. I hope that you saw that there's still storage out there. I hope that you also saw all of the issues that my client pointed out in the 30-day.
Give me, John, go grab the phone, will you?
Additionally, well, if I may add one more thing, Your Honor. Additionally, it's my understanding there's no part that manufactured home. They're actually buried in propane tanks. We can find that out too. And that's not allowed pursuant to the community rules.
I'm sorry, was that last part about what was, I didn't hear that last
You have a
part.
warrant for your arrest, Mr. Castillo. You have to come up here. You understand what I'm telling you?
I do understand.
Why didn't you show up? Everybody else went out there and came back. Why didn't you come in here?
Oh, I didn't know I was meant to come to court. I thought this was going to be a Zoom meeting.
Why aren't you picking up the property, sir?
I had picked up the property upon being here, and as I said, at the other home.
Wait a
family.
minute. Wait. Upon being here, what do you mean by that?
As we said in the last meeting, my family lives with my mother at the time due to the fact that there is no power here. And I was advised to, I need a letter of residency from the community, as well as my ID and a letter from the mortgage company for DTE to start the process. And I have everything except a letter of residency from them. And I was just advised to remain out of contact until this date, as you know, would be best, as they were not willing to work with me in the beginning. So I was advised to not communicate with them about this. But upon everything, if I'm able to get that letter of residency, I can have the power on within 30 days. Their original request was 6 days. I had contacted DTE. They said that is not possible due to the fact that they do have to ensure that I am both the owner of the home and the owner of the lease, and it will take up to 30 days. Because
You
then
still don't have the outside picked up.
I got most of everything picked up. The rest of the stuff I can get done this weekend. The excrement is
I
from
think I
when the dog.
remember them telling me that you were told or asked to do this back in October. Is that true or false?
That's true. We had that conversation.
Oh, this
Your
is
Honor.
March.
Yes, Your Honor. We had that conversation.
This is the
and,
middle of March.
Yes, I have most everything done. The
Well,
only thing
I know,
don't
but you
have-
did that in a day. You were here on January the 27th.
Yes.
Anybody listening to this would have known you have to have that done.
Yes, I have
And
90%
you did
of
not
everything
have
done.
it done. That is a period of about 5 weeks we're talking about here. You could have had that done in an hour.
I just didn't
Assuming,
have- I'm sorry. Go. I'm sorry.
I don't want to hear excuses from you. How much equity do you have in that home?
Without repairs, anything sold as is, it would be about $13,000.
Boy, you got a lot of money there.
Well,
You got
And
a
I
lot
have-
of money if you have $13,000 in equity and you're rolling the dice like you're playing roulette or something by not picking up the property. I mean, I don't know what you're doing. You got bikes stacked back there. I can't honestly say I saw the dog excrement, as you said, but I can tell you that the deck has items that ought not be out there. I don't know what you're doing.
Oh, those are just toys that blew out of that chest and some knocked over pots.
Blew
from
out of the chest. Blew out of the chest? Is that what you said?
Yeah, they're small, light toys. It's little empty, like balls.
Counsel,
Your Honor, this has been going on since July. I mean,
I can-
seriously, since July. We went to court in January. I thought, we're looking at 2 more months. You would think that he would have cleaned everything up. He doesn't care. He doesn't really care about community rules. This has been going on for a long time. I asked the court to terminate the tenancy. He may have equity in the home, but he should have thought about that months ago. And you know how many violations? You only have to be violations. This should have never gone
All right.
before your honor.
okay, but wait a second.
Yes. Why should the community suffer because of him?
Wait a minute, slow down. Mr. Castillo, you're making life difficult for yourself. If you truly have 13,000, and I told my court officer to tell you not to talk to me because I can't engage in conversations out there. You still managed to tell me you were gone yesterday, which is only one day of the last 37 or whatever it is since you were last in court. I don't know what you're doing. You didn't want to let me in. I didn't want to walk in, to tell you the truth. I have this funny feeling I would not have wanted to go in there when you made sure the door was closed. And that's your business, I suppose, what goes on in the interior. But if you want to be a hoarder, you're going to have to find another place to go, sir.
Oh, I'm not a hoarder. I was just advised because nothing from the inside was ever questioned because I don't rent the home from the community. I rent the lot. And I understand the exterior definitely needed to be better picked up. But weather permitting, some of the windy nights and all that stuff.
I thought it was only since October. He's telling me it was since July they've been asking you to pick it up.
That was just the grass. The rest
That
of the
was
stuff,
just the grass, that you weren't
Yeah,
cutting the grass?
because I was
What
between
about
2 to
all
3
those
jobs.
bikes in the side of the yard there?
I'm trying to organize my shed to get those in there. I've got a lot of stuff in there. I'm trying to move things over to get those bikes in there. One of them is actually active. The one that you saw, the blue one, that's
There's
actually
nothing
mine.
wrong. There's nothing wrong.
Here, may I tell the court what the July violation was for?
Go ahead.
Violation.
You know you're not going to win this, right? I'm not going to kick them out.
Well, what is it going to take, Your Honor? Seriously.
You can appeal me if you want.
Well,
I'm giving him 1 week to clean it up. I'm going out and looking. You don't have to look. If it's anywhere near that, I don't care if we have tornadoes between now and next Monday. If you don't have the stuff cleaned up, I'm talking about the scooter, the bikes, everything on the deck, I'm going to issue an order of eviction. Do we understand one another? I'm going to issue the judgment and then the order of eviction. Do we understand one another, Mr. Castillo?
Absolutely, Your Honor.
And
May I?
that is, you have 1 more week. Do we understand one another?
Yes, Your Honor. May I
I don't
note
want to
that
hear that you were busy, that you were working, that something
No.
happened. I don't want to hear any more of that.
No,
I'm
the
not-
moped
I got a
is
heart.
my
I'm not gonna-
actual.
You know, this is $13,000 still, which is probably like $1 million to you. You know what I mean?
I know that, Your Honor,
And I don't mean to be a wise guy about it. But you get what I'm saying.
but I also need you to understand the community here. What? You've driven through there. It's a nice community.
I don't disagree.
And, when you have someone who doesn't care about community rules and regulations, well, either that can, fester onto others.
I know.
That destroyed.
Mr. Castillo, you're playing with fire. March 23 at what time, Jen? You just got to grow up. How old are you, Mr. Castillo?
I'm 37, sir.
Well, it's time to grow up. I can't believe you'd want that, and you're just playing with fire. Are you anti-establishment? You don't want to do what anybody tells you have to do? By the way, I expect you to drive up here and take care of this warrant that you have. Do we understand one another?
I understand, Your Honor.
Today. And if somehow, some way I decide to lock you up and you can't post a bond, I expect that property still to be spotless when I come back on next week. What time we doing this, Jen?
Judge, if you're going back out next Monday, do you want to do it first thing in the morning or?
I got to get it. And we'll do it at 8:45. How's that? I'm going to come and look at the property. You don't even have to be there. If you don't want to come, you don't have to come. I'm gonna go take a couple pictures. I'll be there sometime around 8:15. Will you remind me of that, please? 8:15.
So March
Okay.
23rd, 8:15, and then do you want to do 8:45 here?
8:45 will be it. And I want this in person, Mr. Castillo. You're coming up here today and you're going to be here in person next week. Time to grow up. I've given you multiple chances. I can't believe you didn't have that done. I really can't.
I'm sorry, I'm just a little confused
Sorry,
on
counsel.
the last note with, I'm going to be you want me to show up there today? I want to
Yeah,
just be clear.
got one.
Okay, no, absolutely. Yes, absolutely.
Unless you want me to call the police department and have them come pick you up. That'll make it a lot worse.
No. I was just
Well, then
curious.
drive up here. I expect you here by 10 o'clock. And you get that taken care of today, and you be in court in person next week at 8:45. That's next Monday, March the 23rd. And just let me let you know a secret. Allen Road will not be open. Have a good day.
Thank you, Your Honor.
Thank you. Woodhaven Plaza versus Right Turn Driving School. 2600960.
Good morning, Your Honor. Kevin Taylor appearing for the plaintiff. My client, the property manager, Aisha Cruz, is here with me.
Good morning, Ms. Cruz. Your name, ma'am? Kept on mute, ma'am.
Sorry, Your Honor. My name's
Go on.
Aisha Cruz,
Come
property
on up here.
manager for Woodhaven Plaza.
Is Right Turn Driving School here?
Good morning, Your Honor. We're here. Jason and Kara.
Okay, tell me your full names, please.
Jason Pimer.
And Kara Pimer.
Okay, good enough. All right, did you two listen to and understand the rights on the video?
Yes, Your Honor.
Yes, Your Honor.
Do either one of you wish to speak to a lawyer or apply for funding?
Not at this time, Your Honor.
Ma'am?
No, Your Honor.
All right, so what do you have here? Is this for non-payment? How much is,
Your
how
Honor.
much is owed? Just tell me the total amount owed.
$6,721.25. And to explain it, it's holdover rent. They haven't signed a new lease since 2024. So that's what it is. This is a commercial lease, Your Honor.
How much is the rental rate?
Your Honor, the rental rate with the holdover rate is $1,156.25. The rental rate is $925, but the holdover provision provides for 125% as a holdover.
So how many months do they owe for? 4?
Approximately 29 months of holdover, Your Honor.
29 months?
They've been paying the face amount of the rent, but they haven't signed a new lease and they've not paid the holdover. And we've tried to resolve this to get them to settle or pay the holdover to sign a new lease. And we're kind of at a stalemate, and we're just asking for a possession judgment for this amount.
All right, so the monthly rental rate now, I just want to make sure I understand this. You're telling me is $1,156.25 a month? Am I right?
Inclusive of the holdover, Your Honor.
Okay. Folks, what do you have to say? You gotta either pay up or move out.
Well, it's not an issue of paying, because again, we've paid rent. The notice that we received says rent has not been paid since September 30th of 25, but we do pay rent every single month. I have plenty of documentation.
How much are you
The
paying
issue
per
has
month?
been $925.
But you're not paying the $1,156.25, right?
Correct, because we have documentation from the managers of the property that have stated holdover will be due at lease signing. I've got some documentation holdover. We will discuss with the landlord about removing holdover. We've had conversations for 2 years regarding the property and the condition of the HVAC unit. We have worked with management to get this taken care of. So this stems from signing a new lease. We have tried to sign a long-term lease. We've been here 17 years. We've never not made a rent payment. And in the new lease, They want us to accept the HVAC as is, knowing it doesn't work properly. So we're not able to sign the new lease until we get resolution to the HVAC system. So I've had plenty of conversations with both the managers of the property. There's been 4 since this has transpired. Management of the property and the representative with leasing. And I have documentation that says holdover will be due upon lease signing, which we won't dispute, even though I also have documentation that says it will be removed once we sign a long-term lease. All we need is resolutions to an HVAC system
So
problem.
you're willing to sign the new lease with the increased amount, provided that
Absolutely.
that they take care of the HVAC system?
Correct. And I have in writing that they would repair or replace it with a licensed technician. And we have been distraught for 2 years experiencing a broken HVAC system with them sending out unlicensed contractors to do repairs, and it still does not work properly. So we can't sign a lease accepting it as is, which is what they're asking for, without that working properly. And yes, I spoke to the owner of the property, the landlord, in January. We even said we will agree to pay to have it repaired, but we have to have a licensed contractor that we choose so we know it's, repaired properly. And we want to sign a long-term lease and we can move forward. They have not responded to that since February. We just received this in the mail and were notified. We received it in the mail Monday. The court officer came out on Thursday. So we've done our best to prepare as much documentation as possible. I reached out to Mr. Taylor on Thursday. He said that he wanted to have resolution and they want to work with us and get the HVAC system repaired, that he would contact me back, and he did not.
So far, it doesn't sound like they're being unreasonable, Mr. Taylor.
Well, Your Honor, the tenant's leaving out a couple of very important facts, Your Honor, that I'd like to explain to the court. Provision 19 of the lease, Your Honor, provides that the tenant at its sole expense will maintain and repair the HVAC system. So
Is that the old lease or the new lease?
the current lease is from 2021. They've not signed a new lease. So the
I get
existing
it, but wait a
lease-
minute. Are you saying paragraph 19 of the 2021 lease says that?
Yes, Your Honor. That's a very important fact, that it's on the tenant. And this is common in a commercial matter, Your Honor, but that's what it says in this case. It says that they're responsible. The landlord has spent some money and efforts, but they know that they signed and agreed to do this. So it's their obligation to do it. Also, Your Honor, the lease provides that they accepted the premises as is. They've been there for many years. They accepted, that would be provision 24, Your Honor, of the lease. They accepted the premises as is. I have spoken to the tenant a couple of times. I'm asking for the court to enter a possession judgment only, not a money judgment in this amount. Maybe with that judgment in place, the tenant will, in good faith, work with us to get this resolved. We would like them to stay, but they haven't been paying the full rent all these years, Your Honor, and they've been a holdover
Okay,
since
so
February of 2024.
do me a favor. Tell me again, okay, I get it. When the new lease was going to take effect, what is the differential in the rent between the old rent and the new rent?
Okay, the tenant received a lease for 3 years at the rate of $925 a month.
Okay.
That's still what's being charged before the holdover, Your Honor. Then in March of 2024, they became obligated. So that's 2 years now. They've been obligated to pay the holdover rent, which is $1156.25. They have been paying $925 a month, but they're not paying the difference.
Okay, so that's only $231.25 differential. I'm just curious if that's the case since March of 24. I mean, it doesn't seem to me like it should be 67.21.25. 12 times 200 is 2,400. 12 times 31 is $372. So it seems to me that It should be 2772. You guys, so did you hear what he said? I don't care who wants to speak over here. I'm just going to address you both. He's telling me paragraph 19 of the 2021 lease made you guys responsible for repairs of the HVAC system. Do you agree with that or not agree with that?
I do agree with that, Your Honor, and that is with the stipulation that the reason we signed the long-term contract for 3 years is because we were maintaining a 42-year-old HVAC system that was costly. So the landlord agreed to replace the HVAC at the building in 2021 for us to sign a new lease. So we agreed to that with the assumption it's a brand new unit. So, maintenance should be very reasonable.
Let me just make sure I understand. Wait.
Sure.
You're telling me that somehow, some way, the landlord agreed to replace the HVAC system in 21. Am I understanding you or not understanding you?
Correct. It was
Wait a
replaced
minute,
in.
let me ask you a question.
Yep.
And so based on that agreement, that promise, you're telling me that you went ahead and agreed to pay for the repairs to the HVAC system because you're telling me you believed it to be a new one, you were going to have a new system, right?
Absolutely, yes.
Wait a minute, slow down. Now, let me ask you a question. Does that appear anywhere in the lease?
About replacing the unit? It does
Right.
not appear in the lease. No, I have some documentation outside of the lease.
What kind of documentation do you have?
I even have documentation stating in July of the unit, I guess, the premises of this is that the unit was installed by an unlicensed contractor. So the warranty was voided on the unit from Carrier. We have
Okay, wait a
experience.
minute, wait. So they did actually have it replaced, the
They
HVAC
did.
system, but it was an
They did.
unlicensed contractor, and therefore, and you've experienced problems with it? Is that what you're telling me?
From the beginning, Your Honor. Yes, from the beginning.
Yes.
So if I could interject real short. So I've been teaching I've been in this industry since 1997, a public school teacher since 1997. And I have to come here almost daily since we've had this unit installed for 3 years to make sure the heat is not out. There's been times I've come in here at 2-3 o'clock for a 3:30 class and I have no heat. I'm scrambling to put space heaters in here. I'm calling the landlord. I'm begging for the heat to be turned on because I can't have minors or anybody in a classroom where it's 40 degrees. In the summertime, the AC doesn't work. I can't put 30
Why
kids in
isn't
a
that at
classroom.
least, wait. Let me stop you a second. I get it.
Yes, sir.
Ms. Primer, what kind of documentation do you have?
I have documentation even for going back through 2022 and 2023. I have a letter from Carrier that's the manufacturer of the unit.
Wait a minute. You told me you signed, I don't want to put words in your mouth.
No, I agree.
You told me this, you signed the lease based upon the premise. The two of you signed the lease based upon the premise the HVAC system was going to be replaced. Did you say that or not?
That is correct, yes.
And you signed the lease. Wait a minute, let me finish. You signed the lease in
Yes, sir.
2021, correct?
Correct.
You're telling me your documentation wasn't provided to you, or you don't have documentation of any of these conversations until 22 or 23, right?
Well, to be honest, I believe I have some documentation prior to that, but we only had a couple days notice, so I was pulling all the documentation from 21 and after. But I have documentation in 2024, after the current lease expired, in writing that says the landlord will agree to replace and or repair the HVAC unit with a licensed technician.
What about that, Mr. Taylor?
The lease says that it's the obligation of the tenant to do this, and it doesn't even say licensed. They could use a reputable company to maintain. My client has incurred expenses, even though they weren't obligated to do so, to help. But again, Your Honor, it's as is. That's what they agreed to. It's their obligation to repair. The tenant claimed it only would cost about a couple of $1,000, maybe $1,500 to repair it at this point. And at the same time, they owe over $6,000 in rent that they've been refusing to pay for 25 months. So also, by the way, I did speak to Ms. Pimer twice, and she promised to send me these documents. She never has. I've never seen them. I don't know what she's talking about. And Your Honor does understand and know that to amend this lease, you would need a lease amendment signed by the parties. Letters from carrier, which might be hearsay, and other people, they don't change or amend this lease. It's as is. It's their obligation to repair it.
This kind of seems silly.
Your Honor.
I agree, Your Honor. It has been very, it should be easy to resolve. It's unfortunate the situation that we're in. We've agreed to sign a long-term lease. I've talked about it for years. I'm happy to provide all the documentation that I have. We were put in an unfortunate situation. I have documentation from 2022 from carrier itself who says that the unit poses a fire hazard. It was not installed properly. That was sent to management. They have sent out at least 4 or 5 companies.
Wait. Who made that determination? Who said that?
The carrier team themselves. Carrier sent out their actual, their licensed technicians, and they tried for about 8 months. They came out and would correct it and fix it, and then they determined that it was installed improperly.
Here's what I'm doing. I've heard enough. I'm adjourning this 2 weeks. I'm going to let you guys talk some more. If it's not resolved, I'm setting it for trial. So I'm setting this out until the 30th date. Jennifer, give me a date. And if you guys haven't resolved it by then, I'm setting it for trial. It certainly sounds like I've got enough for a triable issue, but I think I do need to see this documentation you have. So I'm going to ask you to listen to me. I'm going to ask you to make copies of it. I'm going to ask you to bring copies to the court and send them to Mr. Taylor.
Okay.
That's before the next hearing. We're going to have a hearing on March the 30th, Jennifer, at what time?
10:30.
At 10:30. So again, I want to be, it sounds like you have a triable issue. I'm going to make sure I'm adjourning it 2 weeks. If not resolved, I'm setting it for trial. You can converse with Mr. Taylor, converse with Ms. Cruz if you need to, and you guys see if you can resolve it. Again, I'll make a determination finally on the 30th when I have a chance to look at this to see if it creates a triable issue. But I think it does from what I've heard, but I'm not going to guess. So that's what I'll do. If not resolved, set for trial. All right. Anything else
Thank you,
anybody
Your Honor.
wants to say before I conclude here? You guys probably, I'm just telling you, you're handling it okay so far, but you're not going to be able to try a lawsuit. I mean, I don't know what I can tell you. You're not going to be able to do this on your own.
We
It's just
understand, Your
not.
Honor.
So, I mean, it's like using a doctor. We'd all like to do our own medical work too, but unfortunately, it doesn't work that way. So I think strongly encourage you to hire a lawyer. I'll see everybody here on the 30th. Thank you. I'm
Your
not
Honor,
sure.
Your Honor.
Where is your office, Mr. Taylor?
I'm in West Bloomfield. I was going to ask if we could do it on Zoom, Your Honor, if all the
I
documents.
usually let Zoom, but this seems a little bit more, how do I say it?
I prefer to be in person, Your Honor. That way I can provide all the documentation. I think it's a lot better of a situation for all of
Mr.
us.
Taylor, I don't usually require that, but I'd like you to appear in person on this one.
I've been out there before, Your Honor. You have a nice courthouse. I have no problem. Hopefully I can get there. I heard you telling another litigant.
Well, you can't go through, you're not gonna be able to come by Allen Road. So there's another route. And when you get off of 75 there, what is that? Ford Lane. You can get off of West, get on a place called, I think it's Ford Lane, and then go over to Van Horn, but it's not gonna be fun.
Okay, Your Honor.
This place has had trains around it since my father built the building here or was involved in that in 1976. So they're finally going to resolve that issue. So that's going to be nice, but it's going to take 3 years. So it's going to be painful.
Well,
Have a
hopefully
good-
we can get it resolved, Your Honor. If not, we'll see you in a couple of weeks. I was going to ask if your court staff could allow us to meet in a meeting room online to get started, and then we can follow up from there.
Right now, you mean in the breakout
Yeah.
room? Absolutely. They'll
Ms.
do that
Cruz
for you.
and
You
the
guys-
Primers
you
and
guys can
myself.
resolve this,
I think,
and then everybody will be happy, okay?
Thank you, Judge.
Have a good
Thank you,
day,
Your Honor.
everybody.
Thank you, Your Honor.
Don't go anywhere, Mr. and Mrs.
Thank
Primer.
you.
We're gonna put you in a breakout room.
thank you, sir.
All right, Marion Manor versus Jesse Sales in Chioma. And which one do you have? Do you have another one?
Oh, yeah.
Do you?
Yeah, I have Jericho State.
Okay. Let me, she's only got about 4 or 5 here, I think. Marion Manor versus Jesse Sales in Chioma Nuokenta. Forgive me if I mispronounced that. It's 2600784.
Carolyn Cohen appearing on behalf of the plaintiff, Your Honor.
See Jesse Sales, and I don't see Chioma Nuokenta. So,
No, Your Honor, I have not had either of them check
so
in.
you can go ahead and take a default on these.
Sure, there's currently $931.43 in rent,
931.33 in rent?
43.
43, I'm sorry.
$175 late fee. $221.43 in court costs for a total of $1,227.86.
Defendants failed to appear. The relief request will be granted. Default judgment possession, favor of plaintiff and against defendant. Writ date will be the 23rd. And the amount to be paid with favor is $1227.86. Marion Manor versus James Morrow, 2600785.
Move for dismissal without prejudice.
Case dismissed. Motion to plaintiff. Marion Manor versus Mackenzie Carter, 2600786.
Move for dismissal without prejudice.
Dismiss. Motion to plaintiff. Marion Manor versus Ashley Sledge, 2600787. I thought I saw it. There you are, ma'am. Good morning. Your name?
Good morning. My name's Ashley Sledge.
Ms. Cohen, your appearance?
Carolyn Cohen, P49391, appearing on behalf of the plaintiff.
Ma'am, did you listen to and understand all the rights on the video?
Yes.
Do you wish to speak to a lawyer, exercise any of those rights, apply for funding?
No, thank you.
All right. What is the total? Just give me the total amount due, Ms. Cohen.
$1,352.69.
Do you agree that you owe that amount?
Yes.
Can you pay that?
Yes, I can pay it Friday.
Any problem with the 1 week adjournment, Ms. Cohen? I can adjourn it and let her pay that. You're going to for sure pay that Friday though, right?
For sure.
March 23rd at 10. Make sure you pay them by Friday, okay?
Thank you.
And even if you do, just make sure you show up on the 23rd just to confirm that they got the payment and case is being dismissed, okay? That's awful close. If you were to pay it by Wednesday, you'd probably have the dismissal order by then.
Thank
So
you.
we'll see you next week. Thank you. Marion Manor versus Antoine Bailey, 2600788. Bailey, there you are. Sir, I'm going to ask you to take your hat off and tell me your name, please.
All right, Antoine Bailey.
You root for the Dodgers?
Yep.
Where do you live? LA?
I'm from New York originally, but I'm living down here.
All right. I'm just kidding you.
All right.
And they win all the time. Anybody can root for them, right?
Yeah.
All right,
Yeah.
Ms. Cohen, your appearance.
Carolyn Cohen appearing on behalf of the plaintiff, Your Honor.
All right. You listened to and understood the rights, right?
Yes.
Do you wish to speak to a lawyer or apply for funding?
See, the problem is I owe for March. You know, I took care of February, but the thing is, you know, I told the leasing office like, you know, January last month. I tell them every month that I worked airport security, but somehow, some way, we just working for free. They don't have funding to pay us. So I have to look for other ways right now to get money. But, you know, it take me a minute to get it. But, you know, I tell them.
When you say airport security, you working for TSA?
Yeah.
And you're not getting paid.
Yeah, we're just working for free right now. So I have to find other ways to get money until the Democrats and Republicans can get along and find some type of funding bill for us.
Asking two parties to get along is a bit like, all right, Ms. Cohen, tell me the total amount that's owed again. I'm sorry. Just the
Sure.
total.
It's $1,330.
I feel for you guys. I really do. Can you tell me your name, Miss Manager there, Marion?
Margaret Geiger.
Just for the record, okay. Is there anything you can do to help this young man out?
I asked him the last time that this happened to bring me something in, showing me that, something that he wasn't getting paid or even where he worked, but I've never been supplied with anything.
And you work for TSA?
Yeah, it was for to avoid a late fee, but I end up paying the money anyway.
Just let's not talk about that now. I just want to make sure you're telling me you work for TSA.
Yes.
You can bring over some kind of an old pay stub and show that to Ms. Geiger this morning.
I can show them any pay stub, but it has to be like after I get off of work because I'm supposed to be to work at 11 o'clock. But I told her I was waiting on my HR person to give me the paper because they pretty much try and tell us that we need to go on a work verification site. But I said, no, I need it for my apartment complex to avoid late fees.
All right, listen. You have an old check from TSA, right? Like the month old or something?
Yeah.
All right. Let's do this. I'm going to adjourn this 1 week. We'll adjourn it until the 23rd. What time did I give you? Did I give you the 10 o'clock on that day or 8:30?
Yes, it's 10 o'clock.
And you bring that over there and you show them the pay stub, and we'll take this up next week at 10. But I'm only going to be able to delay this so long for you, as badly as I feel for you guys. I really am. I mean, I feel terrible for you guys, but I can't just, I'm just telling you, if you got another place to go, another job to get until this resolves, in other words, working somewhere else for a little bit, I'll be able to help you a little, but I can't just say, well, he's working for TSA and they're not getting paid and that's a farce and that's not right. And therefore, I'm not going to make him pay his rent because that's not fair for them either, or to them, I should say. Where'd he go? I think he disappeared. You see him anywhere out there, Jen? I don't either. Tell you what, I'm going to adjourn that to March 23rd. He heard enough. And that's what I'm going to do.
Your Honor, before you move on, I have one more Hamptons case that I don't believe was called. You called all the Hamptons cases but one.
You have that file, John?
I give you all the 30s.
Okay,
I don't have anything else with Hamptons here.
I have the case that wasn't called as 26-00782, which was the Hamptons versus Alexis Riley Tucker.
All right, let me check.
You threw that. I took it down. You threw that up, right?
Yeah, Alexis Riley Tucker. Okay, we'll check on that. In the meantime, I'm going to go on these other ones. Marion Manor versus Talia.
Morning. Good morning, ma'am. Are you Marilyn Close? And Ms. Close, this is your initial appearance in clause number 25, DCCR 1220. You're charged with the state fail felony offense of fraudulent use or possession of identifying information from June 5th of 2025. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
It's just, actually just got my BCF in Florida turned on, so they just now granted me some money, so I haven't been able to look for an attorney at the moment.
Okay, but you got your VCF?
DCF.
DCF. And so do you think you'll have are you working?
No.
Okay, do you have the money to hire an attorney?
I'm trying to, my niece and my nephew are trying to help me.
Okay.
Get-
So what I'm gonna do, Ms. Close, is reset your case for about 30 days to give you some time to try to hire someone. If you get someone hired before the next court date, just bring the reset notice that you get today to that lawyer and they'll tell you what to do.
Okay.
If you're unable to hire someone, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, have different payment plans. Bring me the names of the lawyers you've talked to so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you would have to go back to jail. Do you understand? All right, if you'll come over in front of the clerk, she has a reset notice for you. Let's see, it's Candy Baraka. This is an expunction. You'll call the name Candy Baraka. Good morning.
Good morning.
Good morning.
Andy Baraka.
All right, so this is cause number 26 DCCV 0267. And Ms. Baraka filed a request for expunction. The state, through the district attorney's office, has filed a response, as well as the city of Beaumont. And it looks like the state's position is that I grant it was in 2 cases. It looks like one is cause number M241026, and then the other is 23 CCCR 2497. State's position is I grant relief on the 23 DCC or CCCR case, but not on the other. Is that correct?
That's correct, Your Honor.
Is it the city's position as well?
Yes, ma'am.
And so it looks like on the M241026, Ms. Baraka entered a plea of guilty and received a probation. Is that correct?
That's correct, Your Honor.
Okay, so then based on that, I will grant the petition for expunction in cause number 23 CCCR 2497, but I will deny it in M241026. And I'll work out and sign in appropriate order. Thank you both.
Thank you, Your Honor.
You'll just put that out, but I need to probably look at her order and make some interlineations.
Your Honor, did you have 2 expunction cases?
I do not she only brought me one in.
Brought you one?
What's the other one?
The other one is Hayden Snyder,
Which
26 DCCB 0265.
right, if you'll help him see. Okay, we'll check on it real quick.
All right, thank you.
Tyrania Johnson. Good morning. Are you Tyrania Johnson? Tariana, sorry. And Ms. Johnson, this is your initial appearance in cause number 26 DCCR 0017. You're charged with a 3rd-degree felony offense of evading arrest or detention with the use of a vehicle from November 23rd, 2025. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
No, ma'am, they appoint me.
Yes, ma'am. So when you're in custody, we automatically appoint you an attorney. But once you bond out, I expect you to try to hire your own. So what I'm going to do is reset your case for about 30 days to give you some time to try to hire someone.
I can hire someone.
If you get someone hired before the next court date, just bring the reset notice you get today to that lawyer. They'll tell you what to do. If for some reason you're unable to before that next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, have different payment plans. That way I know you're actually trying to hire someone. Bring the names of who you've talked to so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you would go back to jail. Do you understand? All right, step in front of the clerk and she'll give you your receipt. Kim just came in this door. Did you see her? I don't, she just came through the door when I was in the middle of that, but then she went back. Is Kim back there?
She's right there.
Oh, got it. Okay. Sylvester Hassan. Google Jefferson County criminal attorneys. Yeah. You also can go across the lobby right here. There's a bar association. They have a referral and they can give you some names as well. You can just Google it and find somebody to talk to. Good morning. Are you Sylvester Hassan? And Mr. Hassan, this is your initial appearance in calls number 25 DCCR 1850. You're charged with the third-degree felony offense of theft of property from November 6th of 2025. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
I've been working.
You have? All right. So what I'm going to do, Mr. Hassan, is reset your case for about 30 days to give you some time to hire someone. If you get someone hired before the next court date, bring the reset notice to that lawyer and they'll tell you what to do. If you're unable to hire someone before the next court date, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts, they have different payment plans. Bring me back the names of the lawyers that you talk to so I know you're trying, and then we'll discuss your options. If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order and you would go back to jail. Do you understand? What's in your mouth? All right. Step in front of the clerk. Oh, wait, Mr. Hassan, I'm sorry. You have another case. Let me go through real quick. You also have cause number 25 DCCL 1851, where you're charged with the third-degree felony offense of evading arrest or detention from that same date. And so you need to make sure when you go talk to an attorney, make sure they know that you have both of those cases. Okay. All right. Step in front of the clerk. Crystal Robinson. Good morning. Are you Crystal Robinson?
Yes, ma'am.
And Ms. Robinson, this is your initial appearance in cause number 25 DCCR 1869. You're charged with the third-degree felony offense of deadly conduct, discharging a firearm from September 27th of 2025. Since you've made bond in your case, have you had an opportunity to hire a lawyer?
No, ma'am. I've been up there.
Are you working?
No,
Why not?
because I'm disabled. I've been working with Middleton. I have some 12 issues.
Do you receive disability?
Oh, no, ma'am.
Okay, so if you're not receiving disability, then that means that you're not technically disabled legally. And so you need to try to get a job. And then after that, try to hire a lawyer. So what I'm going to do is reset your case for 30 days to give you an opportunity to try to get a job. So you need to work on that and bring me proof that you have applied to at least 5 a week. If you get one, great, bring me proof of that. If not, just bring me the proof that you've tried and then we'll discuss your options. Yeah.
That's remote work. How long is the job as well? Can I apply for remote positions?
I don't care. I want you to get a job that makes money, that you can hire a lawyer.
Yes, ma'am.
All right. So I don't care what the job is, as long as it's legal, then you're good. All right.
Yes, ma'am.
If you don't do what I've asked you to do, then when you come back, you run the risk of me raising your bond and you would go back to jail. Do you understand? All right. Step in front of the clerk, please. Mr. Price, let's see, is there a Hayden Snyder? Is Mr. Crenshaw here? Let me see if we can find Mr. Crenshaw before we do that. Would y'all see if Mr. Crenshaw, he has an 8:30 expunction. Simranjeet Singh. Good morning, sir. Are you Simranjeet Singh? And Mr. Singh, this is your initial appearance in cause number 25 DCCR 1870. You're charged with a third-degree felony offense of theft of property from August 28th of 2025. Since you've made bond, have you had an opportunity to hire a lawyer?
Not yet.
So what I'm going to do, Mr. Singh, is reset your case about 30 days to give you some time to hire someone. If you get someone hired before that next court date, just bring the reset notice that you get today to that lawyer and they'll tell you what to do. And if you're unable to hire someone, then I'm ordering you to visit with at least 3 lawyers. They all charge different amounts. They have different payment plans. Bring me back their names so that I know you're trying to actually hire someone. And then we'll discuss what your options are. If you don't do that, then when you come back, you run the risk of me raising your bond if you're not following the court order and you would go to jail. Do you understand?
Yes.
Step in front of the clerk and she'll give you your reset notice. Tiffany Elair. Tiffany Elair. Good morning, Ms. Elair. Were you able to hire someone?
I'm gonna meet with another one.
I can't hear you.
I'm gonna meet with another James Macon and Willard Hall because they originally quoted me was more than what was expected. Somehow we meet with them this week to try to.
Why haven't you met with them before? It's been 30 days.
Because originally I was going with Walker, but he's gonna be more than what I expected it to be.
I have a thought on the case, Judge, that they will dismiss restitution. Restitution's like $1,500. I've explained that to her. I told her you need to protect you to do, but I said, she said she can do it for the next court date. She indicated to me, I said, if you can do that, you need to call me and we can talk. So,
Okay, so talk to Mr. Parker. If y'all can get this worked out before the next court date, then don't go spend your money on a lawyer, spend it on the restitution. You'll have about 30 days. I'm gonna do a normal reset. Mr. Parker's your appointed lawyer. Okay, we'll see you back in 30 days. Talk to him about how to get that taken care of. Okay, thank you. Thomas Valentino. All right, hold on a second. Thank you. Good morning. Are you Thomas Valentino?
Yes.
And Mr. Valentino, this is your initial appearance and cause number 25 DCCR 0121. Sorry, my computer's decided to go slow. Give me a second. You're charged with the state jail felony offense of theft of material, either aluminum, bronze, copper, or brass from April 7th of 2024. And since you've made bond, have you had an opportunity to hire a lawyer?
No, that's when I got picked up from TDC by Jefferson County. I thought I had got court appointed because when I was in there, I got the paper for it.
Yeah, so when you're in custody, they automatically give you a court-appointed lawyer, but once you bond out, I expect you to try to hire someone. So did you go straight from TDC
Yes.
into our custody?
Yes, ma'am.
So did you go, when did you go into TDC?
It was August 8th of 2024.
Okay, so after this one, and you've been in all that time?
Yeah, when I got arrested April 7th here in Jefferson County. Hidalgo County came pick me up 10 days later. And then was fighting the case down there, and then I ended up signing for TDC. And then there was
Mr. Rojas, is he on the docket today? Do you expect him? So Mr. Rojas was appointed to you. I'm going to let you talk to him this morning instead of resetting your case for you to hire a lawyer. If you've been in TDC, there may be something that can get worked out on your case. I don't know exactly what credit we were, and then we had a hold and all of that, but I'm going to have you have a seat. Mr. Rojas should be here in just a few minutes. When he gets here, y'all remind me and we'll get y'all together to talk and we'll see. Okay. Then I'll decide if I need you to hire attorney.
Yes.
Okay. Just have a seat. Javon Johnson. Good morning, you're Javon Johnson. Did you get someone hired, Ms. Johnson?
I was supposed to make my last payment for the deposit to hire Mr. Langston Monday, and then all of the stuff wanted where I had a warrant pop up, you need to be from here. I had 4 days, so if I can have like 2 weeks, I'll be able to.
Okay, all right. So we'll do 2 weeks for you to hire Mr. Adams. If you'll step in front of the clerk, she'll give you that notice. Anthony McFarland. Good morning, you're Anthony McFarland. And Mr. McFarland, were you able to get someone hired?
Talked to, I forgot one name, but the other one was John Langston.
Okay,
I haven't proceeded yet to go meet with them. I forgot what date they told me to, she's like, just come.
so you, Mr. McFarland, this isn't your first time coming back here, right? So I know you've heard me tell, why didn't you write things down? Where are the names of the lawyers you talked to? I told you to talk to 3.
Rushing this morning.
What?
So I was rushing this morning
Why?
because it was 8 o'clock and I was on my way here. I was trying to hurry up and get up to be on my way here.
Where are you coming from?
The West,
The West what?
the West End of Phelan.
Oh, so from here in town.
Yes, ma'am.
Look, how old are you?
19.
19 years old. It's time to set your alarm, get up on time, bring here what I asked you to bring. Because I've now given you how many resets? How many times have you been here?
I only got one reset to go get a lawyer since the last time I came.
How many times have you been here in this court in front of me?
I believe it's my second time. But
Okay. You have 2 weeks.
yes, ma'am.
You don't have a whole month. You have 2 weeks. If you don't do what I asked you to do or ordered you to do, when you come back, I will raise your bond for not following the court order.
Yes.
There will be no exceptions. Do you understand? We need to get someone hired before the next court date, or you need to speak with 3 attorneys, which isn't going to be easy. You've got to start calling attorneys today. You don't know if you can hire them unless you call them and talk to them. Find out what they charge. Maybe you can afford one. If you don't do everything I just told you, then when you come back, you're going to jail. That's
Yes, ma'am.
simple. Step in front of the clerk. I am him. Amon Colbert. Good morning. Are you Amon Colbert? And Mr. Colbert, this is your initial appearance. Clause number 25, DCCR 1849. You're charged with the 3rd-degree felony offense of theft of property from November 6th of 2025. Since you've made bond in your case, have you had an opportunity to hire a lawyer?
I tried to out of Louisiana.
Okay.
But he
So-
never got back to me. He never got back to me yet.
All right, so what I'm gonna do, Mr. Colbert, is reset your case for about 30 days. So you need to try to get someone hired before that next court date. If you do, bring the reset notice to them. They'll tell you what to do. You're from Louisiana? So there's a few Louisiana attorneys that are licensed to practice in the state of Texas, but not all of them. So you probably need to talk to some here locally as well.
All right.
If you don't, and if you can't hire someone, then you need to at least talk to 3. Start calling attorneys, find out what they charge, save your money. Let me know who you've talked to when you come back. If you don't, then you run the risk of me raising your bond for not following that court order. You understand?
Oh, yes, ma'am.
All right, step in front of the clerk. She'll give you your reset notice. Luciana Richard. Good morning, ma'am. You're Luciana Richard.
Yes, ma'am.
Did you get someone hired?
No, I can afford it, but I can speak with them for them.
Who'd you talk to?
Right, Kimber, John West, and Ryan Gertz.
Okay, so are you working?
No, ma'am.
Where's you working?
I'm trying to get childcare for my last baby.
Okay.
So we want to work for us to get child.
All right, so what I'm gonna do this morning, thank you for doing what I asked you to do. I'm gonna have you fill out some paperwork to see if you qualify for a court-appointed lawyer. You need to make sure and fill it out accurately and completely because you're going to swear under oath that it's all true and correct, and then I'll take a look at it, okay? Step in front of the clerk and she'll give you that paperwork. What's the deal? What's that? Mr. Price, Mr. Crenshaw is asking for a reset on Hayden Snyder. I think he tried to get with Ms. Carter last week to do that, but she was out. So that's probably why. So I'm going to go ahead and just reset it, see what's going on since she was on vacation, and we'll let you know.
All right,
Okay,
thank you.
thank you. Okay. Thank you, ma'am. Let's see, Judge Walker, you have Daniel Ward.
Good morning.
Good morning.
Judge, that should be up to the.
Okay.
You have, there's 30 days or less.
Yeah.
We don't need all.
Good morning, sir. You're Daniel Ward,
Yeah.
and this is 25 DCCR 1375. Sounds like there's going to be something worked out with a little time.
Yes,
Like it's a normal
30
reset.
days.
Any issues?
No issues, Your Honor.
All right, I'm just going to do a normal reset. Mr. Ward, make sure you stay in touch with Judge Walker. He'll let you know when you need to be back, and we'll take care of that on that date.
Thank
Okay?
you, Judge.
Thank you. You're free to go, sir. And you've got Laura Adams.
Yes, ma'am. Judge, I think that's going to be more about it. I think we're good. And we can,
Well, let's get her up here just a second.
I was going to say, we can do this unless or included. It's okay with
For what? I'm sorry. Is Laura, hold on. Is Laura Adams here?
she is
You'll,
working away this way.
Judge, we resolved this last week. We were just waiting to see if anybody called in or sent in restitution. And to my knowledge, they have not as of this morning.
okay, so y'all are gonna work it out this morning?
Yes.
Okay, I'll hold it
That's
for that.
okay.
Yes, sir, of course.
Good.
I'll hold it till it's ready.
We're good.
And sorry, ma'am. And Aaron Shetley. Good morning, sir. Are you Aaron Shetley?
Yes.
This is 24 DCCR 0776. Mr. Shetley's charged with assault, family violence, impeding breath circulation. What is the announcement?
2 out of 3 ain't bad. Judge, you said this was the last time the court wants to set it on the file. I think that's fine. I'm hopeful that we can get something to work out, but can't represent that to the court.
So if y'all, I mean, I know that you've been on since August, but the case itself is very old. So I'm going to hold it. Would y'all do a plea bargain rejection of whatever the offer is? And I'll get it set on the trial docket. If something works out prior to that, then just let me know. We'll get it
Okay,
on.
and we will still continue to work towards it since Judge hasn't been on it quite as long. There's some stuff I have that he may not have yet with respect to some stuff that was down the hall. I don't know if he has it all.
Okay.
But we've been here several times, but I'll
Yeah,
I'll
yeah,
give
it's
him
been since August,
my
but we're good.
standard.
Let's do that and I'll recall it.
Thank you, Judge.
Just have a seat, sir. See, is Mr. Alden Samuel here? Mr. Macon, you've got Aaron Ward.
Yes, Your Honor.
Aaron Wars,
Believe he's sitting.
you'll call the name, please.
You know, Mr. Ward has been out of
Hold
town.
on a second. Let's get him in here, please, sir. Good morning. Are you Aaron Wars? This is 25 DCCR 1233. Mr. Wars is charged with driving while intoxicated, third or more. And what is the announcement?
Your Honor, I believe this will be a plea. However, Mr. Wars has been out of town, and then when he's been in, I've been out. So I just asked for a real short recess for a plea.
Okay, I'll do a 2-week reset. Mr. Wars, it's very important that you go see Mr. Macon before that next court date. This will be the last reset, okay? Fernando Flores. Mr. Macon?
He's outside. Oh, no, there you are.
See, Ms. Molfino, this one's yours. Good morning, sir. Are you Fernando Flores? And Mr. Macon, will your client waive the formal reading of the indictment?
Yes, John.
Mr. Flores, in clause number 25 DCCR 1231, you're charged with the state jail felony offense of abandoning or injuring a child from July 6th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you sign these, did you go over them with Mr. Macon?
Absolutely.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal? And it looks like the agreement that you reached is for a 5-year deferred probation. There would be a $500 fine and you would be required to follow all of the rules and conditions of probation. Is that your understanding? Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
You have no objection to 1, Your Honor.
It's admitted. Is there any evidence that Mr. Flores is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of that plea, find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a free sentence report. It'll just give me more information about you and your case, and then we'll come back at a later date for sentencing. You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right over there behind you. Judge, I need your discovery certification as well.
I handed it to you.
I asked that a substance abuse assessment be done with the PSI as well. This was the DWI child passenger that was re-indicted.
Yes, ma'am. If you'll make sure and get a substance abuse assessment as well. All right, and y'all, I'll get that. You can stop. Go ahead and stop at the probation, and I'll take care of that. Make sure they get that emailed attachment to Kelly, please. Mr. Macon on Juan Martinez Rodriguez.
You've already got your time. Yes, a translator.
Thank you. Thank you. Juan Martinez Rodriguez. Good morning. Good morning. And sir, you're going to translate today? What is your name for the record? Antonio Aguilar.
Yes, ma'am.
Would you please raise your hand, Mr. Aguilar? Do you swear or affirm that you're going to truthfully and accurately translate from English to Spanish and Spanish to English to help you God?
Yes, ma'am.
Thank you. And are you Juan Martinez Rodriguez?
Yeah.
So you've got to translate everything I say and then everything he says back.
Yes, yes.
And will your client waive the formal reading of the indictment?
Yes, sure.
Mr. Rodriguez, in cause number 25 DCCR 0017,
And that's what the number?
25
25.
DCCR
This is 0017.
0017, you're charged with theft of property, a 3rd-degree felony. from September 12th of 2024. And how do you plead to that charge?
Como culpa de ese cargo. No contesto culpable. Pues me sentí nomás era una trocamiento. Just not guilty, it wasn't his truck.
General, I would ask we give it a few minutes.
I'll hold the case.
Go back inside.
I think yeah, I don't want to do, yeah, once he comes back, if they want to go through with it, we'll get Jennifer over there to do it. But I'm not gonna, that's one thing for them to. Mr. Kelly, you have Delaney Rodriguez. This is, yeah, it's French. Good morning. Are you Delaney Rodriguez?
Yes, ma'am.
And this is 25 DCCR 0856. Okay. Ms. Rodriguez is charged with intoxication, assault. And Mr. Kelly, what is the announcement?
Yes, Judge, Ms. French has advised me that she'd like some time to speak with the complaining agents.
Okay, so you just recently got this one. Okay, I'll do a reset for you on that one. And then once that takes place, obviously you guys need to get together. You've been on it for a little bit, Mr. Kelly. So let's get an announcement at that next court date.
Thanks, Judge.
All right, thank you. You stay in touch with Mr. Kelly. Once Ms. French talks to him, y'all have some more information. Mr. Jeffries, do you have John Pugh?
Yes.
Morning. How are you?
Doing it now.
Good.
So this morning.
I know, that wind is blowing.
Yes. Oh.
Good morning, sir. You're John Pugh.
Yes.
This is 25 DCCR 1470. Mr. Pugh's charged with aggravated assault with a deadly weapon. And what is the announcement?
We've just received an offer, Your Honor. We'd like one more setting to be able to discuss that, go forward before we decide to move to trial.
Any issues? No. Yeah. You okay?
Okay.
Yeah, sorry, excuse me. No, just ask that Mr. Jeffries please make a request for the video, Judge. And
Okay,
be sure
still
to
some
get
media.
in with the paper trail listening.
Yeah, make sure you get that request in today for the media so that you guys can go over that as well before that next court date. Stay in touch with Mr. Jeffries. Once he receives everything from the assistant district attorney, you'll be able to go over that. We'll get an announcement at the next court date. And if you've already done that, then if everybody just make sure where it is in the process.
Okay.
All right. Thank you, sir. You're free to go.
Thank you.
Thank you. Ms. Holmes, I am signing the dismissal in Mr. Ledette's case. He's free to go. Liz Bradley. Mr. Parker, you have Laura Garman.
Yes, Judge.
Morning.
Good morning, Judge. Oh, thank you, Puffy. Which Luke's case? Was it Laura Gorman? Garden.
Here at the request of probation for termination of community control. Ms. Tranter, does the state have an objection?
No, not at this time, Judge. We had previously set this over because I had information that there may be another investigation and more charges coming for Ms. Musser, but I have a note here from Detective Purdy that no criminal activity was found and that no charges are going to be filed. So at this point, the state has no objection.
Was restitution paid in full?
Yes, I believe so. It was paid at the date of sentencing.
I'm sorry?
It was about $9,200 my dad paid.
All right. Anything you want to tell me?
I've been clean ever since October 19th of 2024. So 3 days, it'll be 17 months. And I've been still going since I got on Monday program, starting early July. I've gone to weekly counseling and I talk to my psychiatrist once a month, and I completed Talbot House in December.
Okay. Is that it? It's been a long road, huh?
Yeah.
Okay. Well, the court will grant the request to terminate you from supervision at this time. Congratulations.
Thank you.
Good job.
You're good to go home. Once the paperwork's signed, I'll mail you a copy and I'll also send you a copy.
All right. Thank you.
Okay, congratulations.
Specifically will be turned over by the state. So I had filed a motion to compel, and in the other court, you only be outside.
And Mr. Langston Adams is your turn. Yeah, I hear it.
Yeah, I'm back. Thank you, Judge. Good morning.
Ms. Zachariah Atterbury.
Yes, sir. All right, Judge, on that case, we do have a discovery dispute. I did file a motion to compel. I did on that particular case. I e-filed it Thursday, and they had me refile it.
I don't have it yet, and I haven't received it.
You do?
I have not.
I got an extra copy I can send you.
Well, I need to give them a notice, but okay.
There isn't one in this file.
This is.
What is it? Tell me.
What happened is that we, on this particular case, Judge, there is some items of discovery where we're in dispute on as to what specifically will be turned over by the state. So I had filed a motion to compel, and I specifically asked for, I'll tell you here. Medical records of Sarah Elbrid's forensic evidence of the scissors, forensics, fingerprints, DNA, witness statements, anybody other than Sarah Elbrid's, and disciplinary reports of officers involved. This is the hit one.
Did you not receive my response?
Yes, that's what I called. And they basically objected to me having those documents. So in light.
It's not true.
I got a copy, you put objections.
Okay, go ahead.
Yeah, so what happened is that state responded to my request for those things. in the email, and I got the email, and I included it as an exhibit to this motion. The state objected to me on several of those things. So I filed a motion to compel the hearing. Yep. So, like, for example, the state objects to medical records, serial illness, forensic science, no documents in possession, no documents, witness statements. One of the things that she mentioned was police reports, disciplinary records, no documents responsive. I mean, at the end of the day, I mean, the state got to make an effort to go to them and go get it.
Yours, those documents exist. Those documents don't exist. We don't have those in possession. That's why I'm putting on there, no documents.
Right, but like for police officers, internal affairs, did you go and see if they asked?
There's no documents that's aware of all those officers. You're basing this on my motion in limine. That's why you saw this. There's no documents.
Like I said,
as entertaining as this is, what's going to happen is this. You've been on the case for 2 years. This thing is over going on. I don't know. It's 27 months old. And here on the day of the trial, we're bickering about something that should have been done years ago for us. So we're going to move forward one way or the other. That's your problem, y'all's problem. Y'all got to work that out. But waiting for after 27 months and then on the day of the trial, y'all are at odds over discovery. There's no excuse for that. We're putting it on the docket today. That thing done earlier. Okay. Secretary, Glenn Duckett, we're gonna go away. Oh, you're up.
Yeah, Judge, I'm Mr. Duncan, Mr. Ham is giving me an offer, a different offer today. Let me talk with him. Mike is asking myself.
No, don't do it on front of loud and everybody. We got 30,000 people watching. Talk to them privately.
Let me convene Mr. Ham, talk to him right now.
Okay. Well, me know. All right. Marvin Parker. Marvin, please.
That's you.
Yes, that's me. Ready.
Aggravated robbery on that.
Is there anything, any of these? Y'all work out?
I may be. Me and Mr. Ham spoke this weekend, and I need to talk to
Jason Altman.
The same thing. I'm gonna talk to him a little bit, but already otherwise. But yeah, these raw cases have been set for all times already. But I want to make some. See if I can get all.
Trial on Altman will be 608.
Donnell Anderson. Joe. Are you on the trial docket?
No, sir.
Oh, okay. Get your. You catch me when you're pacing. When you're pacing.
Oh, okay.
It's like the baby's about to be born.
Good morning.
Donnell Anderson.
Your Honor, I've been preparing with Jimmy for the murder trial. So
what about you, Joe? Y'all ready or not?
We're still talking about it.
It's 660 days old.
We should be able to come to a resolution and not have to try this.
660 days old.
Yes.
When will that be? In our lifetime or y'all's lifetime? A week or two?
Yes, Judge.
In your lifetime. I don't know
when do you think we can come on? Really?
Or the next trial setting, whenever it's set again. And if not, the state will be ready to proceed at that point.
Set in 2 weeks for announcement, one way or the other. Fisher touch base. Okay.
Thank you.
Arthur Gilder, Mr. Wilkerson. On today? Today?
I've made a lot. It's I have 9 of the 12 cases I'm trying to move.
Okay, I know you're gonna, but you're gonna try. That's all. I understand. And that you.
I'm doing my best to try to move the rest that I'm not trying today, Judge.
Thank you. My client's indicated he does need to take the new offer. So if you give us just a couple minutes.
Sarah Simpson, Samisky. Sarah Samisky.
Copy of our paperwork from the hospital. I received.
More Miss Misty, they notified me she was in the hospital last night.
She just wanted to hear.
She says she was so.
Who is that? Who is that? That's one of the most chronic conditions in America right now.
We would like to get the case resolved. Mr. Hans made a new offer. If we could get it, maybe it's special setting officer. All
I can do is roll it over to the next trial.
So you may be.
Once since she's online, we could send out.
This is not the kind of case I want to send out.
Okay,
Judge.
that's fine.
This involves the death of the child. Not that I question other.
The resolvement of it?
To expedite it, he's made, Mr. Hans made a 15-year cap offer, which I haven't been able to, he made that over the weekend when we were texting, but I could run that by her to see if she would be amenable to taking that. Otherwise, I'd like to just try to get her.
Okay.
On trial.
Just gonna roll it on to the next docket. Okay.
And if Mr. Hans doesn't want to become over, storm it out, it's fine. It's just. I asked the mom to email that to me, and I can probably get a bunch of copy of that.
So yes.
And that's from the ER.
I've got great eyes. It's hard to read.
If she was admitted or not.
I'll get a cleaner copy, Judge.
Just to be a bigger.
Make sure I put that. I just wanted you to have something.
That's from yes, well.
Yeah, there's a diagnosis. I can't.
I think it says anemia.
Okay, it was just too tiny.
Let me pull it up.
What about Judge Monday? You said you were gonna be gone next Monday. I'm getting ready for it. You see, it's coming. How are you? Okay. I should have put the on already. I'll send you a file offer and put it on that for you. It's deferred.
I think it says anemia.
I know, but I mean, she checks in the day before the trial. You know, I mean, you always find that hard to fathom on a Sunday where, yeah, anybody can go to the hospital, but the day before the trial, we're having a rash of those going to the hospital and checking themselves in the day before the trial.
Another indicator is the second time disabilities. I'll leave it to the court's discretion.
Well, is she not here? And I'll just roll it to the next trial, I think.
I think she may be looking.
That's the one. And then 115. Something like that. Yeah, it's a loose here. It depends on when the jurors can go and get checked in, but yeah, that's good. And John. John's lined up as the backup.
All of it, Judge, that are things I'm not ready on. That's the equivalent of a murder. I can do, I'm just trying to find this back. Not that all this.
I think it's, you're talking about Lionel LeBeau?
Yes, sir.
You want to see if I call him one day?
Jason Arcus.
I can do any of the other cases on that front page except for arguments, because that ag assault is dealing with paralysis, and it's the equivalent of a charge.
Are you already on Arcus?
That's what I'm saying. I'm not ready on that one. I'm ready on everything else on that page, but that one requires.
Martin first. And LeBeau, 2. And where's John? Where are y'all on Marvin Parker or Jason Altman? Those are John. Okay, and then Parker is 3, Altman's 4.
I know, she's got it.
And Mr. Wilkerson is.
Hey, we gotta move. They're both moving out. It's been taking about. But I have.
Okay. Where's Dustin Galvin? He said he's ready on. Andrew Lakey.
Right now, but basically, so we're not. If we go from. Yeah, we're not. I just had to make sure that if she was.
You said Wilkerson was going to work something out?
Yes, sir. We're gonna have our plea on the calendar.
On, I know, I'm just
making sure.
Jimmy Ham's
I know.
is the star of the show, and it's just he can't be in 2 courts at one time.
Unfortunately, I have but one line to give. Famous judge quotes that off.
All right. The prosecutor on Zachariah Atterbury. Erica, y'all ready on that? Okay, I'm gonna send that one to Judge Templeton. Also Glenn Duncan, but that's Jimmy.
Yes, sir. That's mine.
He's stuck on everything else. And we can do that. It just didn't work out. Nine of the 12 were Mr. Ham's case.
Why amazing?
Aren't you the lucky one?
I'm feeling really blessed this morning, Judge.
Okay, that's what, once again, Arnold 1. So.
And
LeBeau, did we say Ronald LeBeau?
We said LeBeau.
It's 2.
Parker and Altman, 2, 3, and 4.
And it's Jason Altman and Arnold LeBeau, Parker, Altman. Those are all jail cases, but only non-jail. Mr. Wilkerson's case, I think he's trying to work that out. And then Atterbury and Duncan. But I can't pull Duncan because of Jimmy. Atterbury goes to Judge Templeton. All right, that's that. Thanks. You're pacing. No. And just. I want you to just like do some side straddle hops like you did in high school. You know, side straddle hops. Hold on.
Yeah.
Is it Ryan Anderson?
Yes,
Okay, that's it.
sir.
Tomorrow.
No, what we're doing, we're sitting both of mine for trial.
Okay, what's the other one?
The other one is July.
I didn't see them. Yeah.
It's all there with the lock with. Yes. And I spoken with Mr. Henry.
How'd that go?
Always perfect.
I see. Ryan.
Ryan Anderson.
What?
No, be on the jail.
Yeah, I know. I see Ryan Anderson. I don't. Let's see. Yeah, I'm sure it's there.
Deontay Joel,
Yeah. Okay, those two. Okay, so what are we doing on this?
Set for trial. Jerome was already set for trial in that case. But we thought we might be able to resolve. So I won't both of them say, but Mr. Anderson, I mean, like, speed the trial. Look, yeah, I know.
Well, speedy.
Well,
we have a trial every trial docket. I don't know. You can't get it more speedier.
I know, but that's where we are. Okay, sir.
All right. Well, it's sexual assault. Those that's to priority status as a law.
It's not a child, it's an adult.
It's an adult. Yes.
So it doesn't get the statutory preference, but it certainly gets preference.
Your preference. And our preference.
All right. So on Anderson, set that one quickly, please. And Jerron, set that as. Oh, you're right. That's over 2 years old.
Yeah, it was previously on the trial docket, had a different lawyer, Mr.
Anderson is fairly new, it looks like.
Yes, sir.
But is he in custody?
Yes, sir.
Oh, okay. Well,
Still.
yeah, let's get that tried and
You are?
On the trial docket quickly. And then Jerron, that's all. You've got to be sensitive about that. Thank you.
Thank you, sir. What time?
Yes, sir. Richard Langston Adams. Langston's got the first 4 pages. Tom Burbank. You got a bunch of them here at the beginning.
Yes, I got signed up and I'm signing up Annie Matthews as we speak.
Okay, I've got Philip Bennett. That's MTRP announcement. Philip Bennett, 2 cases. Yeah, that's on the Jose. Okay.
It's a big child. I think one day I don't want to say parents of it, I'll move back where it's facing it. All right. I'll move it away. Yeah, great. I'm moving back. Yeah.
Okay, we've got Richard Banks. And then
Philip Bennett, we still waiting on labs on that case. Here.
okay. When did that, March 11th?
Yeah, that's recent. That's good.
Yeah.
So on him, I'm still waiting on labs.
Who's on this plea?
Okay.
Philip.
Erica.
You can take the position. Yeah.
There's 2 MTRPs on this one. Here, thank you.
Okay, that's all we still waiting on labs.
Yes, we will.
Here's this. Here's a sign that announced.
So there's been.
I need a bunch of those.
I'll give them each.
Okay, I'm Philip Bennett. Two motions were filed on October 30th. And BWI, that would be intoxicated. It looks like it's all about that event.
Yes.
Except for there's some community service and we were just in payments. Yeah. Okay, I'm gonna review this in 2 weeks.
That's
okay. Hopefully we'll have something there. And Jose Buendia.
He was, his report came back and found him.
Okay. That's health-wise sounds good.
Right. I believe that was in February of 2026. Dr. Wilwell did the report.
It's like we've got
it was a
second degree arson and there's an enhancement for a robbery file. So now we're looking at up to life in prison.
And I also on that is a child of 8, but I think it'd be a good idea to bring him out so you can.
What are you at?
He said, he told me when I asked him about the cafe, he said no, but I think that if you
just do what?
Just, well. Just.
Want to put it on record?
Yeah.
Offer.
That'll work.
Okay. All right, let's try that. Jose Buendia.
Right. But he did come back as counsel.
Mm-hmm. A bunch on one, to be honest, whole page, 5 of them. You are Jose Buendia?
Yes, sir.
And Mr. Adams is here representing you. You were charged in. So. Y'all ready? Y'all ready?
Yes, sir.
You're charged in 25 CR 1443 with an indictment charging you with arson. If convicted, that's a second degree felony, which carries with it up to 20 years in prison. This also states in the indictment that you have previously been convicted of robbery in 2015 out of the court next door. If that were true, proven true, you were convicted of this arson, then your punishment range goes up. You're looking at life in prison, up to life in prison, no less than 5, no more than 99 years or life in prison. Do you understand what you're facing your service? Okay. What's the plan? Was there an offer made?
Yes, sir. The offer that I conveyed to my clients was a cap of 8 years. And I told you about the cap of 8 years, but you know, take that, it's not take that.
So, well, here are his options. If that's what it is, it's then no less than 2, nor more than 8 years in prison. You could be placed on deferred or unadjudicated probation. Also, you can be placed on regular probation. Since you're not allowed probation if you are sentenced to more than 10 years, but they're capping it at 8, that gives you the opportunity. What we would do is, if that's what y'all are going to do, then we would order a pre-sentence report before any decision was made, so everybody knew what his full background was. And that would put you in a better situation. But anyway, all of that is semantics. Today is the day. What do you want to do? Which route do you take?
If I'm said it's going with an agreement of the 2, I saw for 2 unknown.
It's not what, they said a cap of 8, and so it would be the court's decision no
That's
less.
7 years last time. You're not getting less.
Yeah. That's what the sentence was on the Robert. That's what's normal under law. You never get punished less for subsequent criminal behavior. It's trial, no deals. There is no deal. We'll just send it to trial, and you're not eligible for probation. So let a jury decide that. We'll set it to trial. Thank you. That is all. Next is Travion Clark. Okay, what are you doing on Banks?
On Banks,
Is it are you paying?
I'm ready. I can play right now. Send the face to you. You want to do it?
No. Yeah, whenever my coordinator shows up.
It's all good.
Yeah, she'll be. All right.
But Banks,
ready on Richard Banks
Oh, well, we did last one.
trials as soon as possible. No deal.
Thanks, yeah, that'll be.
I got that. Mr. Gordon. Makes sense. It's good to see you, bro.
Right, for workers, so let me know if you're self out. Okay. You got your sometime, right now, yeah. Like, yeah, it's so much cheaper. You get it one more time? Let's see. Okay. Thank you.
I'll let you have to.
We now call 25 CR 1435, the state of Texas versus Richard B. Banks. Is that you?
Yes, sir.
Present with your attorney and the state's attorney. Does the defendant waive a formal reading of this indictment and the arraignment thereof?
Yes,
Yes,
sir.
proceeding.
Yes, sir.
In summary, this indictment that was filed on October 8th of 2025 states that on September 10th, 2025 in Jefferson County, Texas, you committed the state jail felony of forgery. And it looks like I try to not pay attention to the show. Structure. Forged to read a check in the amount of $4,892.53 to you on behalf of the Balfour Ring Company. A refund, purporting to be a refund for ring and jacket.
Represented by Ms. Diefenbach, and we have Mr. Harris in the prosecutor's office. And no, you're not on this one. We are here today for a pretrial. It's my understanding Mr. Andrus going to enter a plea of guilty to 1 count of aggravated possession of drugs. We're going to set this for sentencing. Is that accurately stated?
Yes, sir.
Mr. Andrus, how old are you?
39.
How far did you go in school?
I got my GED.
Are you able to read and write English?
Yes.
Are you under the influence of drugs or alcohol?
No, sir.
Are you taking any medications?
Yes, sir.
What are you taking?
Suboxone, Triliptal.
Let me ask it this way. Are you taking anything that would interfere with your ability to understand what we're doing here today?
Oh, no.
Are you a United States citizen?
Yes.
We've had some discussions about your case. If you enter a plea of guilty to this charge, I'm not going to sentence you today. Instead, what we're going to do is conduct a level 2 pre-sentence investigation. We're going to set this for sentencing probably via Zoom because you're at CCC still, right?
Yes, sir.
When's your out date tentative for CCC?
Like May, midway through May.
Okay. So the plan is to set this for probably a Zoom sentencing while you're at CCC. I intend to put you into my community control program and have you complete the CCC program for me also.
supervise you after your release. That's probably where this case is headed. Other than that, has anybody made any threats, promises, or representations to get you to plead guilty to this against your will?
No.
I have a document entitled Change of Plea and Entry. It looks like on the second page, there's a signature above the line defendant. Is that your signature?
Yes.
Did you review this with Ms. Diefenbach before you signed it?
Yes, sir.
Are you satisfied with the representation that you've received in the case?
Yes, sir.
Once upon a time, I got an email that said that you and her were not getting along. That's not the case, at least anymore, right?
We had a talk.
Okay. I mean, I don't care what happened. I just want to make sure that you're okay with the representation that you've received in the case.
Yes, sir.
You're going to enter a plea of guilty to one count of aggravated possession of drugs, 5th-degree felony, punishable by up to 12 months in prison, $2,500 fine. If you violate the terms of your supervision and I have to send you to prison, the maximum penalty also includes an optional period of post-release control of up to 2 years. Before we go any further, I want to make sure that you understand your rights. You're presumed to be innocent in this case. That means that you can't be sentenced or punished until you either plead guilty or the state of Ohio proves that you're guilty. If they can, they have to do that unanimously to a jury or to a judge beyond a reasonable doubt at a trial. You would have the right to confront all the witnesses against you at the trial, compel witnesses to testify on your own behalf, and you have the right to remain silent. If you enter a plea of guilty to this charge, you're going to waive all of those rights. You're going to admit that you did it. We're going to get on to the matter of the sentence. Is that what you want to do?
Yes, sir.
Mr. Harris, what are the facts?
Your Honor, if this matter proceeded to trial, the state would show beyond a reasonable doubt, in addition to all allegations in the indictment, that on or about December 5th of 2025 at the Turtle Creek Center in Turtle Creek Township, that's in Warren County, Ohio, the defendant Jeremy Anders possessed methamphetamine. It was lab confirmed at 0.0348 grams.
Anything on the facts?
No, sir.
Mr. Anders, did you hear those facts?
Yes, sir.
Do you admit they are true?
Yes, sir.
Do you understand the rights you're giving up by entering plea?
Yes, sir.
Which plea?
Guilty.
Based upon the plea of guilty, I'm going to find you guilty. I think that you've made a knowing, voluntary, and intelligent choice here today, only after you have been fully advised of your constitutional rights, which you waived and rejected here in open court. I'm not going to go into the matter of the sentence today. Let's make it an L3 because it'll be easier for them to do from CCC. So we're going to do a level 3 pre-sentence investigation. We'll see everybody back here in about 30 days. Okay?
I had the matter of transportation.
What's that?
The matter of transportation. Can we do can I schedule the sentencing for Zoom?
Yeah, I mean, that's the plan right now.
Okay, that's his plan. All right,
Yeah,
thank you.
you don't have to worry about transportation. Somebody will drive you or we'll do it by Zoom.
All right, thank you.
But let's plan on doing it by Zoom. Okay, all right, that's all.
Okay.
You understand what you're charged with?
Yes, Your Honor.
Where'd the check come from? Your ex-girlfriend?
She wrote it this year.
Well, what did you do wrong?
We need to know that.
Okay, y'all work together on this? How'd you get a Balfour Company check?
Well,
Well, like I can understand that. I can understand things. Just tell me what.
It's like it's a group of kids that be doing that be getting some paperwork. I don't know where they get it from, but I guess they go through people mailboxes and stuff. Yes, sir. I can't really tell you where.
But the original check, it was just plain check?
Yeah.
Or did it have writing on it?
Yes.
Yeah, okay. So somehow somebody's gotten about full company checks. And this is a state jail felony. And does the defendant waive a formal reading of this?
Yes.
And we'll proceed in summary. In summary, this states that on or about September 10th, 2025 in Jefferson County, Texas, you committed the state jail felony of forgery of a financial instrument. And it is of a value of $2,500 or more, but less than $30,000. That's what makes this a state jail felony. It was $2,500 or more in value. This was written for about twice that, $4,892.53. How'd you come up with that number? Just invented it?
Yes, she did. I did.
Is she charged? Was she charged too?
No, it was just me. She was in the vehicle at the time.
She was what?
She was inside. She was inside in the vehicle at the time. She does have a record.
If convicted, you are facing confinement in a state jail for any term of not less than 180 days or more than 2 years. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes.
An agreement's been reached.
Yes.
Agreement has been reached where you would be sentenced to 2 years in state jail. That would be suspended. You will be placed on regular probation for up to 5 years in length, fined $500. And is there restitution?
There is no restitution.
There is none. Is that your understanding of the agreement?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will. And because you are guilty. It's one line. Here, you're gonna sign this. Yeah, don't use your pen. It's probably in real foundation. Here's marked as State's Exhibit 1. Did you sign that document, Mr. Banks? Understand it? Discuss it with your attorney?
Yes.
Are the contents all true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence.
No objection.
And without objection, it's admitted. Among other things, this states that you are mentally competent to enter your guilty plea, which is freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You are guilty of the crime charged in any lesser included offense. You're giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All of this is true. It states, so help you God. Correct?
Yes, sir.
Yes, we got. States Exhibit 1, part of the record for all purposes. Pre-sentence report is away.
Yes, sir.
I'm going to follow this agreement. I will find that you are mentally competent to enter your guilty plea. It is freely and voluntarily made. You know and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted now in this hearing that you signed to find you guilty beyond a reasonable doubt. And I now find you guilty beyond a reasonable doubt of this state jail felony of forgery of a financial instrument. And this is in an amount exceeding $2,500. I'm going to follow this agreement. You are hereby sentenced to confinement in the state jail for 2 years. That will be suspended. You are placed on regular probation for 5 years. There will be a fine issued, $500. There will be terms and conditions of probation, which are normal and customary for this type of offense. Have you been convicted of a crime before?
Yes.
Generally,
but
people don't hesitate on that answer. You know it or you don't know it. Were you convicted or not?
Not convicted yet. No, sir.
What does that mean?
The statement's true. She's trying. I don't know. I'm really new to all of this, honestly. What he had.
This is your life. You ought to know a conviction follows you around for the rest of your life. Generally, you would know. Is it from this area or no?
No, sir.
It's from where?
Yes, pending case in Harris County.
That's it?
Yes, it on.
Sessions.
Oh, yeah, prior possession.
Okay.
He had a prior possession too. What's a prior possession? So prior happened in the past.
Possession.
Possession of what? Baseball cards, gambling paraphernalia,
Control
drugs? Oh, okay.
Was that?
Where was that?
It's in Harris County.
What happened in that case?
Well,
What was not what the facts were, but how were you punished?
I was supposed to take drug classes, and my mom was on drugs too. And I didn't really feel comfortable staying with her, so I moved back to Beaumont. And I didn't go to my random drug tests, so that's why I got a warrant for my arrest again.
So, and was your probation revoked?
I didn't get no probation or anything. I just need to take a random drug test. This is possible.
That doesn't make any sense. Was he on deferred? Is that what it was?
It doesn't, for disposition, it just says that he has a possession of controlled substance, on 8/7/2020.
But it doesn't show a disposition.
Doesn't show a disposition.
That doesn't help us at all. I mean, that's just a waste of words. I don't know. But probation office is going to be supervising you there. You're going to see them.
Yes, sir.
They'll know. They can find out. They always know. They can get to the bottom of the information before I can get it. So if you fail on your probation can be revoked and you can be sentenced then to 2 years in state jail. Okay. So follow the P's and Q's and the conditions of probation. See that, man? Thank you. That is all. It's the same. So I said, this. Oh, we don't see this. Did you decide you're going to do on Jose Buendia?
You said that was a dollar.
And then I mark it down. Trevon,
I just want to put the all on the road.
where's does he need to be out or?
I think because he looking at, I think at 4 cases.
Let's see. Nope, he's got 5.
5. Yeah, I was close. You know.
That only counts of horseshoes and explosives.
I know, right? The all pro with the council team. That's Mr.
Trayvon
Clark.
You're Trayvon Clark? No, right there's fine. You're Trayvon Clark?
Yes, sir.
You have 5 cases here. 5. Which one's bad enough, one conviction is bad enough. You can sit down. We got security issues and nobody stands up except the bailiffs. Okay. Thank you. Unless you leave. Do you know him? Who is he? All right. In 23 CR 1079, we'll start with that one. You're charged 3rd-degree felony of having a prohibited weapon. That carries with it up to 10 years in prison. Next one is 23 CR 1712, state jail felony of attempt to commit theft of property. A Kia automobile, it states. from an elderly individual. Okay, so that carries with it up to 2 years in the state jail. Then 23 CR 1716 is another state jail felony. And that is unauthorized use of a motor vehicle. And it's not the same about that.
No, sir.
No, it's a different person.
Yes, sir.
That carries with it up to 2 years in the state jail. And then 24 CR 1018 is first degree felony of aggravated robbery, which carries with it, if convicted, no less than 5, no more than 99 years confinement in prison or life imprisonment for that one. That's the most serious one of the bunch so far. And then 24 CR 1019, a third degree felony of evading arrest or detention with a motor vehicle. That carries with it up to 10 years in prison. Do you understand all of this? Okay. So I think what we have is
He's got 28 priors. I'm trying to look at.
okay. So on best I can figure out on this, you're looking at 24 years in prison, up to 24 years in prison and life in prison. All of this together. So it's a bundle of 5 that are serious. You say he's got a prior conviction?
No, sir.
Oh, I thought that's what I heard.
No, that's a separate case we're talking about, Judge.
Okay, so what are we doing today?
Judge, the offer on those cases were a cap on 10 on the ag robbery and evading, and then dismiss the remaining 3. I did convey that offer to him this morning. Do you want to take it or not take it? You say you're not taking it?
Okay, and then was it the aggravated robbery?
Yeah, I'll try that one first.
That's what we're gonna try first.
It's the one he
And
confessed.
there are no deals then. No deals. Okay, that's it. Missed that chance. And we'll go on that one first. All right. Dondre Davis.
Good morning, ma'am. Are you Laura Garman? Yes, ma'am. And will your client waive the formal reading of the indictment?
Sure, Your Honor.
Ms. Garman, in clause number 25, DCCR 1007, you're charged with the state felony offense of driving while intoxicated with a child passenger from August 22nd of 2024. And how do you plead to that charge?
It's the lesser included, Judge. Sorry.
Hold on. I see that now.
Included Class B.
Let me get this pulled up. Sorry. Take that
You
back.
don't really have a whole lot of place to write on the state judge.
No, it's good. And I had it pulled up. I just didn't. All right. So let's start over. In 25 DCCR 1007, the state has elected to proceed on the lesser included offense of a Class B misdemeanor DWI from August 22nd of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? Yes. And because you did what they've charged you with? Yes. I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Parker? Do you fully understand them? Yes. And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? And are you a U.S. citizen? Yes. And it looks like the agreement.
Your Honor, one thing that in Michigan, we usually agree on the community service. I didn't put that on there. Standard, it's like 60 to 80 hours. And I just forgot to include that. I didn't ask Mr. Nichols about that. I just.
Probational. Yeah. I'm
Okay.
sure they'll take care of
Okay.
whatever standard.
Okay.
Sorry, hold on a second. Now this is going. And so it looks like the agreement is for a 180 day in the day term in the county jail. That would be probated, though. You'd be on probation for 1 year. There'd be a $500 fine, and you would be required to follow all of the rules and conditions of probation. That includes the standard community service and everything else that goes along with probation. Is that your understanding? State tenders number 1.
Actually,
It's admitted. Is there any evidence that Ms. Garman is not competent?
no, Your Honor.
All right, ma'am, I'm going to find that you entered your plea of guilty to the lesser offense of a Class B DWI freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequence of your plea. Find sufficient evidence to find you guilty, and at this time, find you guilty of DWI and the Class B, and sentence you in accordance with your agreement to a term of 180 days in the Jefferson County Jail, but that'll be probated. You'll be on probation for 1 year. You'll be ordered to pay the $500 fine, and again, to follow all of the rules and conditions of probation. If you do that, then for all practical purposes, your case here in court is over. You'll serve that 6-month sentence while you're out on probation. The other side of that is if you violate any condition of probation, you can be brought back into court and you could be sent to the Jefferson County Jail for that 6-month term that you've agreed to. Do you understand? Yes. Right. You need to, I'm handing you the trial court certification that shows this was an agreement that I followed. And so you've waived your right to appeal. You need to have a seat here in the courtroom. Probation's going to call you up when she's ready to go over your paperwork. She's sitting at that desk right there. So be watching for her to call your name. Okay. All right. Good luck to you, man. Thank you.
I have fun. Ashley needs to explain my other case.
They are. Are they ready? Okay. Thank you. Okay.
Can I call the name, Judge?
Sir?
Can I call the name?
Sure.
Tori Anderson?
Okay, Mr. Macon, y'all can come back up on Mr. Juan Martinez Rodriguez. And we're going to use the court's interpreter for the plea. Sir, you can have a seat. I think that might be easier with the language. And good morning, ma'am.
Good morning.
Would you please raise your right hand? Do you swear or affirm that you will truthfully and accurately translate from English to Spanish and Spanish to English?
Yes, sir.
Thank you. And so we've already gone through Mr. Martinez Rodriguez. Hold on a second. Let me get it pulled up again. All right, so to the charge of theft of property, how do you plead?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you did what they've charged you with?
Yes, Judge.
I have here on the tablet some documents that have your signature on them. And the state's marked them as exhibit number 1. Before you signed these, did you go over them with Mr. Macon with an interpreter?
I just looked at the money, so stop it, was to see this because don't get you all about it. Maybe. Yes, Judge.
Do you fully understand them?
Yes, Judge.
And do you understand if I follow the agreement that you've made with the district attorney that you will be waiving or giving up any right to appeal?
Yes, Judge.
It looks like the agreement that you've reached is for a 5-year deferred probation. And there would be a $500 fine, and you would be required to follow all of the rules of probation. Is that your understanding?
Yes, Judge.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
it seems to be in the same. So if the local don't be like that, they don't have values that are some. Yes, Judge.
State tenders number one.
We have no objection to states one, Your Honor. However, I have talked to an immigration lawyer and run the plea by them, and with his status and all, he has a green card. He's been a resident alien for 2 years. They don't foresee any problems with this.
Okay, thank you, Mr. Macon. Is there any evidence that Mr. Martinez Rodriguez is not competent?
No, Your Honor.
Mr. Rodriguez, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. And that'll give me more information about you and your case. And then we'll come back later for sentencing. On your way out of the courtroom today, you need to stop and talk to probation at that desk right over there. All right, thank you. And if you'll help him just real quick with that, thank you so much for coming down. Thank you, Mr. Megan. Let's see, we did Laura Garment, right? Tori Anderson, Mr. Parker. Sure, I'll hold Tori Anderson. Just have a seat, ma'am. What about Jessica Wilkerson, Mr. Parker?
Get both on that.
Sure.
She's in the hallway, Judge.
Jessica Wilkerson. Thanks again.
You're welcome, Judge.
Good morning. How are you?
This is the new officer, Casey Shadman.
Hi, is it Shepherd? Shagwa. Shagwa, I'm sorry. Just made that a fresh part. Nice to have you. See, are you Jessica Marie Wilkerson?
Yes.
And do you also, has it been Otis at one point as well?
Yes, please.
Okay, and this is cause number 15-2194. Ms. Wilkerson is on probation and there's been a motion to revoke unadjudicated probation. And what is the announcement?
Your Honor, I'm working with Buffino and trying to coordinate with Allstate about a possible settlement of this whole matter. And I think she can probably better explain it to the court.
Judge, I have spoken to Ms. Jones about this. I've spoken to Brenda in bookkeeping several times as well. She has sent me over the to-date restitution of $161,934.28. Mr. Parker and I have discussed several times a lump sum payment to be made to Allstate. I've received all their contact information. I have made multiple attempts to contact them every known possible way that bookkeeping has to contact them. I sat on hold last week with somebody who then said, well, you can call this district manager, but he's not going to answer. I left a voicemail. I will try that again if the court would give me one more chance. I think she wants to make some kind of a substantial payment, obviously not anywhere near the 161, but if they're in a position to want to settle the matter for 50 or 60,000 and she has that, I ask the court allow us to try to make that happen.
Sure. So
If not, we have another way to work it out.
okay. And that's the main issue, right?
Yes.
Everything else is fine. All right. So I'll just do a normal reset. Ms. Wilkerson, make sure you stay in touch with obviously your probation officer and Mr. Parker, and then we'll see what kind of information we can get hopefully before that next court date. All right. You're pretty good. Thank you, Ms. Jones. It was nice to meet you. You too.
I'll get you these. I'll give you these.
Mr. Kemmler, you've got Jorge Del Fiero. Jorge Del Fiero. Good morning, sir. Are you Jorge Del Fiero? This is 25 DCCR 0892. Mr. Del Fiero is charged with assault, family violence by impeding breath or circulation. And what is the announcement?
Your Honor, I have asked our investigator to bring the complaining witness in, and I'd like to gather some medical records before the state makes any kind of offer on this case.
Okay.
Can we have a normal reset?
Sure. We'll just do a normal reset. Make sure you stay in touch with Mr. Kemmler and your bondsman. They'll let you know when to be back. All right. You're free to go, sir.
Thank you, Your Honor.
Thank you, ma'am.
Sure, good question. I'm here, we're out of report on Raleigh on it.
Okay. What is your name, sir? Say the last one.
Chavaria.
Chavaria. Mr. Chavaria on Ronnie Oliphant.
Judge, I thought motion.
Well, Joe, I tell Mr. Comerford he couldn't get it taken care of, but obviously you could.
Yes, Your Honor.
Mr. Oliphant, I'm signing a dismissal in your case right now. You're free to go, sir. Thank you. Yes, thank you, Mr. Coleman.
On the Tori Anderson, this is one that Ms. Malfino needs to look at the video. She, I think Ashley did, Tori Anderson. Is that I think she wanted one reset, so she may dismiss it when she sees the video, but
Okay, on Tori Anderson. Is in Ms. Anderson?
She's here, Judge.
Okay, I'll just do a normal reset and
I thought we could maybe plead it to a lesser, but that was my misunderstanding. So I'll
Okay.
try to get it worked out a different place.
Is she in the courtroom?
Ms. Anderson?
Ms. Anderson, make sure you stay in touch with Mr. Parker before that next court date. Once he gets some more information from the assistant district attorney, we'll see what we're gonna do in the case, okay? You're free to go. Mr. Burbank, you've got Jaden Chandler.
Here you go.
Good morning.
Morning.
Good morning, sir. You're Jaden Chandler.
Yes, ma'am.
This is 25 DCCR 1481. Mr. Chandler is charged with engaging in organized criminal activity. And Mr. Burbank, what is the announcement?
Right, I just need a short brief. That's two reasons. One is I've got to go over, I've got everything from the state I need to go over with him. He had several issues come up. One was that he's had major surgery on his hand and has been back and forth to the hospital trying to reattach it.
Okay.
Major. Number two, he just got a job at a plant in Beaumont. So the time schedules, they've made an offer that I think will take care of it.
I'll just do any issues with the normal reset. We'll just do a
No.
normal reset. That should give y'all plenty of time. Make sure you make some time, get in and visit with Mr. Burbank, and we'll get an announcement at the next court date.
Yes.
You're free to go.
Maybe excuse.
Yes, sir. Thank you.
So I was saying.
Mr. Crenshaw? On Laura Adams, what are y'all doing on that one?
I just put it in the.
Okay.
You ready?
Yeah, we'll go ahead and y'all come on up. By the time everybody gets up here, it'll be on my tablet, hopefully.
How are you doing? Good. You get the exercise, something.
We're not liking them chairs.
All right, let's see. This is gonna be a last minute. All right, ma'am, you are Laura Adams, and will your client waive the formal reading of the indictment?
She will.
Ms. Adams, in cause number 25 DCCR 0870, the state has elected to proceed on the lesser included offense of a Class A misdemeanor assault And that's from April 28th of 2025. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? I need you to answer out loud.
Yes.
And are you pleading guilty because you did what they charged you with?
Yes.
I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with your attorney?
Yes.
Do you fully understand that?
Yes.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yeah.
And it looks like the agreement that you reached is for a 2-year deferred probation. There would be a $500 fine. You would be required to follow all of the rules and conditions of probation, including having no contact with the victim in the case and no employment in child care. Is that your understanding?
Yes.
And are you a U.S. citizen?
Yes.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Ms. Adams is not competent?
None.
Right, ma'am, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of that plea, find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings for a period of 2 years and place you on probation. You're ordered to pay that $500 fine, to ordered not to be employed in any type of child care, and that's privately as well. That's not just with an employer, but for your that can't be privately either. To have no contact with the Brielle Irwin, and to follow all of the rules and conditions of probation. And if you do all of that, this is an excellent opportunity because you don't have a conviction on your record. And at the end of the probation, if you successfully complete it, the case will actually be dismissed. You'll never have the that misdemeanor conviction. The other side of that is if you violate any condition of probation, you can be brought back into court. You could be found guilty of the offense and go to the Jefferson County Jail for up to 1 year. Do you understand?
Yes.
I'm going to hand you the trial court certification that shows this was an agreement that I followed. So you waived your right to appeal. And so if you'll just have a seat here in the courtroom, probation's going to call you up to her desk when she's ready to go over your paperwork. She's sitting at that desk right over there. So just watch for her to call you. Okay.
Okay.
Good luck to you, ma'am. Thank you, sir. Let's see. And then on Aaron Shetley, are y'all doing a do y'all see a rejection over there on Shetley? Would you look and see if there's something on there that needs to be signed, please? See, Ms. Holmes, you have Christopher Davis, a sentencing.
Your Honor, good morning.
Good morning.
Before we get started, Mr. Davis had asked, well, I have a couple letters to give to you.
Hold on a second. Let's get, is this Ms. Frank? Got a sentencing on Christopher Davis?
Good
morning, sir. You're Christopher Davis?
He did want me to request a possible.
Hold on a second until she gets up here for, look at this. Sorry.
Did you get that rejection on it? I did forward it to you.
Oh, yeah, it'll be here in a second, I'm sure.
Thanks.
All right, okay, yes, ma'am.
Your Honor, Mr. Davis wanted me to request if this could be continued to a later date due to him visiting MD Anderson. There was a CT scan performed where they saw some abnormalities. They have requested that he do a follow-up visit within the next I'm assuming, few weeks with Dr. Rajman. And so due to that, we are requesting if this to be continued one more time for him to I guess get some answers as to if there is actually a diagnosis.
I really would rather go ahead and go forward. I don't, well, I'm going to obviously give Ms. French an opportunity to make argument, even though there's some long criminal history. It is old and it looks like, are you on a deferred probation in Kenny County right now? And so it looks like he's been on that probation. And this offense actually happened before that one. And so me sending him on a state jail felony to state jail at this point doesn't really make sense. Just based on the nature of how old this case is and the fact that he's already been on a felony probation that out of another county that he's been doing satisfactorily. It looks like there's no motion to revoke that probation or anything like that.
And I believe he's doing courtesy supervision here.
Okay, so I honestly, based on that, and Ms. French, do you have serious issue with that position?
I don't, Your Honor. He took responsibility and was cooperative.
I have a star next to that. It's very rare. From the very beginning, took full responsibility.
And even while he has been revoked so many times, as the court stated, these are old cases, and I would defer to the court as to a sentence on this case, particularly given these circumstances.
All right, so any of the objection then to going forward with sentencing? Then Mr. Davis, at this time in clause number 25, DCCR 0010, I'm going to find that you previously entered your plea of guilty freely and voluntarily. I'm going to, I guess let me go back up. I have reviewed that pre-sentence report, obviously from my statements. Y'all both have that report, correct?
Yes, Your Honor.
And any additions or corrections or objections to that report?
No, Your Honor.
And I did receive this as well. Ms. French, if you wanted to take a look at that, it's just a letter from the defendant, his mother, and then some medical documentation as well. Any reason then not to go forward with sentencing?
No, Your Honor.
All right. So again, I'm going to find that you entered your plea of guilty previously, freely, and voluntarily. Find sufficient evidence to find you guilty. And I am at this time going to find you guilty of the state jail felony offense of theft of property. I'm going to sentence you to a term of 2 years in the state jail, but I'm going to probate that. You'll be on probation for 5 years. I'm going to order a $500 fine and that you follow all of the rules and conditions of probation. If you do that, then this is a great opportunity because you will be able to serve that 2-year sentence that I gave you while you're out on probation instead of in custody. The other side of that is if you violate any condition of probation, you can be brought back into court, your probation revoked, and you could be facing the 2-year sentence that I just gave you. Do you understand?
Yes.
I'm handing you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Ms. Holmes. If you'll just have a seat here in the courtroom, probation will call you up to her desk when she's ready to go over your paperwork. Thank you. And I'm going to let you keep that since I took a look at it too. And you have Takarian at Gilbo, Ms. Holmes?
Yes, sure.
Good morning. Are you Takarian Gilbo? Excuse me. And this is 21-36753. Ms. Gilbo, is charged with unauthorized use of a vehicle, 2021.
Yeah.
What is the announcement?
If we could get one more reset, Your Honor, I have met with her. We have received an offer from the state. We just need to have some time to review and we'll be prepared to.
Okay,
do something.
sure. I'm going to do a normal, any issues?
No, Judge, and the other two co-defendants have been disposed of.
Okay, thank you. I'm going to reset your case about 30 days or so. Make sure you call, make an appointment, visit with Ms. Holmes before that next court day, okay? All right, y'all free to go. Aaron Shetley. Aaron Shetley.
I fully understood. Doing 3 quarters out of 30.
That's not bad. That is not bad. I'll take that all day, every day.
Knock on wood. It's supposed to.
All right, so are you Aaron Shetley? Again, and so Mr. Shetley, in cause number 24, DCCR 0776, you're charged with the 3rd-degree felony offense of assault, family violence by impeding breath or circulation from October 22nd of 2022. And what that means, sir, is that if you go to trial and you're found guilty, the range of punishment would be between 2 years and up to 10 years in prison. Do you understand?
Yes, ma'am.
And I have here a plea bargain rejection that you've signed that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty in your case.
Just a part, Judge. I didn't put a term.
Okay.
We did.
Deferred probation. Okay, so for a deferred probation, which is, I'm sure you've talked with your attorney, is a type of probation where you don't have a felony conviction on your record if you successfully complete it. You have every right to reject that offer and have your case set for trial. I just want to make sure you understand what the possible consequences are if you go to trial and what your options are if you wanted to plead guilty. And do you understand all of that?
Yes, ma'am.
And do you want to reject that offer and have your case set for trial?
That's correct.
All right, we'll get it set for trial. Obviously, if something changes with any negotiation, y'all let me know as quickly as you can before trial. All right, thank you, sir. Stay in touch with us. Walker, he'll let you know when to come back. We haven't seen Charlie because I've got because as soon as he gets her, I want him to talk to somebody. Yes, ma'am. Okay. Mr. Samuel on Terrell Coker, I think we can give him more. Our case wasn't indicted in February, but he was in custody all that time at TDC, so. Yeah. So we probably could legitimately do it from the data. Oh, sorry. Coker. Hold on a second. Ms. French on Terrell Coker.
I had a chance to visit with Ms. French. I've been next door. But
I'll hold the case.
please, I'll come back.
Okay.
I want to talk to Ms. French.
All right, y'all go have a seat. Corey Richardson, Mr. Crenshaw, that's a set for a plea today. Are y'all doing the paperwork on that?
I think we got it.
Oh, I'll hold it until sorry, I don't see it yet. What about, let's do Timoteo Castaneda, that's a sentencing. It's already done.
She was standing outside.
I think they called her name. I know they called her name.
Called her name?
Yeah.
Okay, all right.
No, her name was called, and I guess I can explain it to her in a minute.
Okay.
Yeah, just
All right.
give me just a second. Need a sentencing on Timoteo Castaneda, please. Good morning, sir. Are you Timoteo Castaneda? And Mr. Castaneda was previously in court, entered a plea of guilty to indecency with a child by sexual contact. I've received the pre-sentence report. Has everyone had an opportunity to review that report?
We have, Your Honor, no additions or corrections.
Same Penn State, Your Honor.
All right, any reason not to go forward with sentencing?
No, Your Honor.
No.
All right, sir, I'm going to find that you previously entered your plea of guilty freely and voluntarily. Find sufficient evidence to find you guilty. However, I'm going to follow the agreement that you made with the district attorney and defer all proceedings and place you on probation for 10 years. You're ordered to pay a $500 fine and to follow all of the rules and conditions of probation. That will include being on the sex offender caseload and following through with any required treatment. They will also do a substance abuse assessment to see if there's any treatment needed for that. Whether you think you need it or not, if they say there's treatment needed, you will be ordered to follow through with any recommendations. You're also to abstain from the use of all intoxicating substances, including alcohol. If there's any issues with your ability to do that, talk to probation and they'll get you the help that you need. Finally, in addition to the other regular conditions, you will have no contact at all with Saul Villalobos. That's obviously in person. That's through any other means. You can't send messages, electronic contact, anything like that. If you do everything that you're supposed to correctly on your probation, then this is a great opportunity because at the end of your probation, the case will actually be dismissed and you won't have the felony conviction on your record. The other side of that, however, is if you violate any condition of probation, you can be brought back into court and you can be found guilty and facing a sentence anywhere in the range of punishment, which is between 2 years and up to 20 years. Do you understand? You already signed and went over the sex offender registration requirements paperwork. It is very important that you keep up with that and make sure that you're registered appropriately at the right place, right time every year, okay? I'm handing you the trial court certification that shows that this was an agreement that I followed, and so you've waived your right to appeal. You just need to have a seat here in the courtroom. Probation will call you up to her desk when she's ready to go over your paperwork. All right, good luck to you, sir. Thank you. Let's. Mr. Galmore.
Hold on that if it's Megara, he was freaking out in his office to make a quick phone call. It might help us resolve it.
If what, I'm sorry?
That was on Megara.
Yeah, it is.
1 second, he's calling his office.
Okay, sure. Mr. Lewis,
Yes.
do you have Janisha Jackson?
Yes, ma'am.
Good morning. How are you? So, Janisha Jackson, Ms. French.
I'm signing it now, Your Honor. There was a glitch with the tab.
Oh, I'm sorry. Let me, I'll hold that a minute because they'll have to do fingerprints and everything. Just have a seat. Watch for the clerk. She'll call you up in a minute. What about Autumn Payne? I'm ready on that one. Autumn Payne, come up, please.
Morning, Judge.
Good morning.
Lewis.